The next case is John Gibbons versus Kendera Construction. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time, please let me know, as I'll be keeping track of the time. The arguments are being recorded. When you present your argument, please introduce yourself, keep your voice up, and remain behind the podium. You should not use the names of children, minors, and victims during your argument if that applies. If it does apply, please use terms like the child or initials. We've read your briefs and are prepared to proceed when you are.
May it please the court, my name is Brent English. I represent Kendera Enterprises and Jeffrey Kendera in this case, although Jeffrey Kendera is not an appellant. I would like to reserve 5 minutes of my time for rebuttal. Your Honor? Okay. This is a case that is a little confusing. Kendera Enterprises is a trucking company, a corporation in Ohio. It was not sued in this case. In fact, Mr. John Gibbons sued a company that's different, called Kendera Construction, Inc., claiming that a rock fell out of a truck that belonged to Kendera Construction, not Enterprises, those are the two distinct entities, and damaged his windshield. He made a claim with his insurance company. They paid him something like a little less than $1,000, and he had a deductible on his policy, and so then he sued Kendera Construction for the $500. It was unclear to my client whether, because he had spoken with a representative from Kendera Enterprises and was making claims against people who worked for Kendera Enterprises, that we may have potential liability in this case. So he filed this in the small claims court. We showed up in the small claims court to advise the court that we do not represent Kendera Construction. Kendera Construction is not there. We don't object to a judgment against Kendera Construction. It's not our issue. We, however, object to any kind of a judgment against Jeffrey Kendera, who is the principal of Enterprises, or to Enterprises itself. We presented articles of incorporation showing that Kendera Enterprises was different than any other company, and the opposing party came up with a Facebook advertisement that he thought showed that Kendera Enterprises was actually the liable party. We told the judge that's not the case. I had 2 individuals testify that although Kendera Enterprises was involved, it was not sued in this case, and so therefore there could not be a judgment. Nevertheless, the trial court held that because of a Facebook posting, that the 2 entities, Construction and Enterprises, were the same, and that we somehow had pierced the corporate veil of Kendera Enterprises and that it was liable. However, when he issued his judgment, the trial judge, this was a visiting judge from Bedford, he found in favor of Mr. Gibbons against Kendera Construction. We asked for permission to get findings of fact and conclusions of law because we weren't sure what in the world the judge was doing. However, unfortunately, I had some very serious medical problems, and although I would have loved to prepare a request for findings of fact and conclusions of law, which I did in a timely way, I did not prepare proposed findings of fact and conclusions of law as the trial judge requested. So he issued a judgment in December that spells out what his analysis was. Now, not dealing with the issue of piercing the corporate veil, but finding that enterprises and construction were the same entity, and then entered a judgment against Kendera Construction. So given that circumstance, we felt it necessary to appeal.
So then
to-
why, if you're not that entity, why are you even here? Because wouldn't that just be a judgment against a non-entity? How would it be collected?
We were, it couldn't be collected. It could be collected against Kendera Construction, which is a separate entity,
A
But-
separate entity owned by enterprise
No.
or not related to?
has nothing to do with it. It is the grandfather of my client, Jeffrey Kendera. It's a different company, does different work, and is owned by a guy who's 86 years old. We weren't sure whether to appeal or not. We weren't sure what the trial court meant by this is the same entity. And so out of an abundance of caution, because we didn't want to be stuck with a judgment where someone would say, well, even though the judgment was against Kendera Construction only, it should also be considered against Kendera Enterprises because of a finding of fact that the trial
If
court
it's
made.
not against enterprises and that's who you represent, do you even have standing to bring an appeal?
Likely not.
Right.
I told you this is confusing, and I brought this action in the Court of Appeals merely because we were so uncertain as to what was being claimed here that we did not want a subsequent claim that Kendera Construction, that for which there is a judgment not appealed, so that's fine, is the same entity as enterprises, and therefore they attempt to collect against enterprises, and we have more troubles. So I respectfully suggest that there is no jurisdiction. I brought the appeal prophylactically, and when I read both briefs again today, I thought to myself, oh, what are we doing here? So, based upon what the court has indicated, if you have any more questions, I'll be happy to answer them. I just wanted to tell you what the situation was. Here, thank you.
Thank you.
I'll reserve any more time for rebuttal.
Your Honors, good afternoon. May it please the court, my name is Lori Hartman. I'm here on behalf of appellee John Gibbons in this matter. I'm likewise confused as to why we're all here today on this matter for a multitude of reasons. One thing that I found confusing in the briefing, we were not involved at the municipal court level, so when our client got the appeal, we were sent the file to sort of figure out what was going on at that point. And one of the things that hasn't become clear to me, and maybe it's as a newer lawyer, but the assignments of error are against the appellee, not against anything that the trial court did wrong. So I was unsure about the standard, did a lot of research about what even the standard is at this point, what's being asked of this court, how they're being asked to review this. It is my very green understanding that there was a judgment, there was a judge, he weighed the evidence, and as long as there was some competent, credible evidence there, then we give deference to what happened at the lower court. I guess on that, I would rest on my brief unless there's any questions, and the appellee requests respectfully the court affirm the trial court decision.
I have a question.
Sure.
On this issue of standing. So the court finds in its entry that Kendera Construction and Kendera Enterprises are the same entity.
Right.
So I think we're all on the same confusing page here, but do you think that that finding is enough of enough to make Kendera Enterprises aggrieved by this, giving them standing to appeal?
I don't know that I'm qualified to answer the question of standing in this matter. I think that there was competent, credible evidence in the record for the court, for the judge at the lower court to make that factual finding. I think the phone numbers are the same, the address is the same, the Facebook is the same. I think the court looked at those things. So in terms of the issue of standing, I'm not sure. I didn't brief on that. I didn't prepare on that specific issue.
And that is a very good answer, because we're all aware that this is being argued today and that but we're trying to get to the resolution. So sometimes you get these questions from the bench and you haven't had an opportunity to brief it, and it is okay to say that.
Okay, thank you. If there's nothing else, then I'll rest on the brief. Thank you.
You have a full 5 minutes if you want to take it for rebuttal.
I do not want to take it for rebuttal, other than to say that Ms. Hartman indicated that the two entities, construction and enterprises, are the same entity because they share a name, a geographic region, and marketing. That's what is said in the brief. I think all of that is incorrect. It's a different name. Obviously, they work in Northeast Ohio, but that does not make one corporation liable for the other corporation's actions. And importantly, the thing that matters most is the judge below. Let me just read this. Accordingly, the court finds that for the plaintiff against defendant Kendera Construction. We are in agreement with that, but we are not in agreement that there is that Kendera Construction and Kendera Enterprises, Inc. are the same entity. That's all we have to say. Thank you.
Thank you both for your presentations. The court will take this matter under advisement and issue a ruling in due course. The clerk of courts will mail you a copy of the decision on the day it's released. Also, our opinions are posted on the Ohio Supreme Court website. Thank you again. The court is now adjourned.